Welcome back. Today we're discussing upskirting and whether there's a need for new law. Now, in case you're not familiar, upskirting can broadly be defined as the taking of a voyeuristic photo up somebody's skirt, either with a camera or a smartphone, in public, but without their permission. Now, upskirting has been in the news quite a lot recently, with criticism that the law in its current state doesn't adequately protect those who are victims of upskirting. So the law that currently deals with upskirting is something known as outraging the public decency. It's a common law offence. It's been developed over many years. It's quite old. And it now, in its current form, boils down to two primary components. Now, the first component is that the act needs to be of such lewd character to outrage the public decency, but the second is one which is much more important to this discussion, and it's called the two-person rule. The act must take place in a public place, and it must be capable of being seen by two or more persons who are actually present. Now, it doesn't matter whether these people see the act or not, only that they're present and they could have seen it. So the two-person rule is quite problematic for the offence of upskirting. Now, it should be said the majority of upskirting will be encompassed by this offence because the majority takes place in crowded public places. Think of festivals, shopping centres, crowded public transport. These are the hotspots for this type of offence. The people who often take these sorts of photos will use the cover of the crowd to disguise the fact they're taking them. However, there are lots of possible instances, and no doubt instances that have already taken place where this has occurred, but where there won't be two people who can view it, or nor will there be two people present. Think of an example such as the night tube, where there may be just one woman in the carriage, but it's otherwise deserted. A man comes onto the carriage, he takes an upskirt image of the woman. This act itself would not get protection from the offence of outraging public decency. If there was nobody else on that carriage, there was nobody to see it, it would fail the two-person test, so it would not be able to be prosecuted. Now, that's just one example. There could be many. For example, the same situation might occur on a lift. There's often not more than one or two people in a lift. And if there was only one person able to view the act, then it would not find protection under outraging the public decency. So it becomes clear once the offence of outraging the public decency is looked at in detail that it's quite obvious that it doesn't adequately protect all of the instances where upskirting could occur. So you'll probably be thinking, well, what about voyeurism? This is more of a voyeurist sort of act, not one which is outraging a public decency if they can't see it, but one which would more appropriately be dealt with in an offence of voyeurism. Common sense would agree with you, but the law doesn't. There is an offence for voyeurism, and it's found in Section 67 of the Sexual Offences Act 2003, but it only deals with private acts. So what it says is that it's essentially illegal to take a picture, record or watch something which is a private act if you observe somebody doing a private act, but that he knows the other person wouldn't be consenting. But the problem when it comes to upskirting is the words private acts in Section 67. Wearing a skirt in public is not a private act. Taking a photo of somebody on the toilet obviously is a private act. Filming somebody in the showers at the gym, obviously a private act. Wearing a skirt in public is not. So voyeurism, the offence of voyeurism, has no teeth in this situation. You would not be able to prosecute somebody taking an upskirt photo of the person on the deserted tube carriage. You would not be able to bring a prosecution there. So there's obviously problems with this gap in the law. But there's still a problem with those that pass the two-person rule and are prosecuted under the offence of outraging the public decency. And that is because that particular offence is designed to protect the public. It's not designed to protect the individual, although in certain circumstances, of course, it would. But protecting the public is its primary focus. Upskirting is a crime which particularly offends the individual. It does offend the public as well, but it's primarily offending an individual. and that isn't catered for in that particular offence. So even those who pass the two-person rule, the offence still seems inappropriate in itself. But there's also a second reason, and that is that incorporating the offence of upskirting into voyeurism, rather than the common law offence, is that this would mean that those offenders are placed on the sex offenders register, which currently they're not. Now, whether your opinion of the sex offenders register is that it works well or it doesn't work well, irrespective of that, it should be consistent and applied universally to sex offenders, which only in its current state, sex offenders where the offences fall under the Sexual Offences Act are placed onto the Sexual Offenders Register. It would make sense then that the definition of voyeurism was extended to include upskirting so that those who committed it were placed on the Sex Offenders Register. So the new law that should be imposed, it seems sensible then, would to be that extension of the definition to voyeurism. It's already been done in New Zealand, it's already been done in Australia, many US states have also done it and criminalised it specifically, creating its own offence. New Zealand, to take one, has the offence of intimate covert filming. From 2006 this was made law. And it's similar to the law of England and Wales, though it includes both private and public settings. The voyeurism offence for England and Wales does not include public settings. So, looking at the solution then, it seems obvious that the extension of the definition would both resolve the gap in the law as well as assign the offence to more appropriate legislation. So is it likely to happen? Well, David Lidington, the current Justice Secretary, actually has given quite a positive response in terms of the press coverage for reform in this area. He says that he takes the issue very seriously and is actually taking legal advice on whether it should be added to the Sexual Offences Act of 2003. So it does seem as though perhaps it might be likely for it to actually change within the parliamentary term. Of course, it does depend on how the reform is drafted in terms of whether it'll be effective or not in solving that gap in the law. But the attitude so far does seem to be one which is positive. So that concludes our podcast. Thanks very much for joining me, and I look forward to seeing you next time.